Good morning. We're starting at a few minutes after 10 a.m. This is a hearing of the Bethany Beach Board of Adjustments for the purpose of considering an application submitted by C&J Cole LLC, the property owner for the property identified as Block 33, Lot 4 at 867 Garfield Parkway in the R2 Residential Zoning District of Bethany Beach, Delaware. Applicant seeks variances from Section 425 zoning, Section 425-2 from the definition for a planned residential development. The application requests that the requirement for a PRD to contain a minimum of 50,000 square feet be waived to allow them to proceed with plans to develop a 3-unit PRD on a lot containing 42,535 square feet. Let the record show that 4 of the 5 members of the board are present. Actually, I should state that 4 of the present 4 members are present. We'll get to that in a moment. I ask that each of the board members speak his name for the record at this time in order to facilitate identification of voices in preparing the transcript of this proceeding. My name is Michael Loftus.
Good morning. My name is Sherwin Weinstock.
Good morning. My name is Jack Gordon.
Good morning. My name is Steve Boyce.
Thank you. We also have with us Susan Frederick, the town's building inspector, and Raylene Menominee, the clerk to the board. The application and associated documents are part of the record and have been marked as Appendix 1. Before we begin, we have a brief housekeeping matter to attend to. Because Richard McHugh was sworn in as a member of the Bethany Beach Town Council on March 15, 2024, he resigned his position as a member of this board effective that same date. At the time of his resignation, he served as secretary of the board. The board thanks Mr. McHugh for his valuable service to the board and wish him great success in his new position on the town council. At this time, because we need a replacement secretary, I call for nominations for that position.
I nominate Steve for that job.
All right.
I will second that.
That nomination is seconded. All in favor? Aye. Let the record show that the 3 members other than Mr. Boyce have voted in favor of his appointment at the position of secretary. So we're very grateful for that. Thank you. We're going to depart a little bit from the normal procedure because, Susan, we haven't had an opportunity to discuss this, but there is a question about whether the mailing requirements of Section 427-107 have been satisfied. We have among the items in the packet you prepared an exhibit that shows the surrounding properties for this property in question at this time. Before I start that, do you swear or affirm to tell the truth in this proceeding?
I do.
Okay. This is the document I'm referring to.
Yes.
Are the properties within that circle the properties that were supposed to receive a notice by mail?
As far as I know, yes. They gave a list of all the properties to send mailing to.
Well, the reason I ask is that if you look at this document, at the very top, there are 1, 2, 3, 4 properties, to 6, depending upon whether you look at the entire property or just a portion of it, that did not receive mail notice. They are not on the list.
Okay.
So how can we determine what the situation is there?
So they're not on the list of mailing? Then
Correct.
then they didn't give us a proper list, as far as I can tell.
All right. Who will be speaking for the applicant? Please approach.
Good morning. My name is Ray Blakeney. I'm with Plitco Engineering. We're located at 53 Atlantic Avenue in Ocean View, and we prepared the plans and the exhibits for this variance application.
Okay. And are you familiar of the document that
Yes,
I've been referring to?
Yes, I prepared it.
Okay. And do all the properties that appear within the outlined area sit within 200 yards?
To the best of my knowledge, yes. Besides the visual exhibit you have there showing the 200-foot line around the property, we also provided a list of names. My understanding, at least, my intention was that that was a complete list. If there was an oversight, we weren't made aware of it. But like I said, to my knowledge, that the list was complete that we submitted. I don't have a copy of what we submitted with me, but I do have one back at the office.
All right. It just so happens that one of our board members, Sherwin Weinstock, he is a resident of Lake Bethany.
Okay.
And is familiar with the properties, and is it correct that you have reviewed the list, and some of those properties shown are not on the list? Sherwin?
Is he,
Sorry, I was asking you.
is he
Oh,
talking about
oh,
these?
oh.
They're on the list.
They're in Lake Bethany, is there?
Well, that's,
The one with the map, they're not on the list.
The list behind it, the map?
The
I
the
have a
properties
feeling
on
that-
the lake.
Can I see the list that was given to you? Yeah.
I have
He
2
didn't
pages.
copy the back page.
We did not receive the back page?
That's correct.
Oh, okay, well, that helps.
All right. And the back page does contain those?
Yes, it does, sir.
All right. Okay.
Thank you, Susan.
You're welcome.
All right.
Or I did not. I don't know.
Having overcome that, would you please have a seat while we proceed?
Sure, thank you.
Thank you.
So, Susan,
Yes, sir.
did the town place a notice of this hearing in public places?
Yes, it did.
And where were they placed and when?
Good question. The property was posted on March 14th, 2024. It, I believe, was posted around town March 14th, 2024. Notice was sent by mail March 14th, 2024. And the website, it was put on the website March 14th, 2024. It was published in the Wave newspaper on the 19th of March, 2024, and in the Coastal Point on March 15th, 2024.
All right. Did you place a notice of this hearing on the property?
Yes, I did,
867 Garfield Parkway?
March 14th, 2024.
Okay. All right. In the absence of objection, I find that notice of this meeting has been posted, published, and mailed, consistent with Section 425, Part 107. Do we have copy of the posted public notice?
The board secretary does.
You have a copy of that? All right. That will be marked as applicant's Exhibit 2. And the newspaper proof should be marked as applicant's Exhibit number 3. Okay. As we proceed with this hearing, all testimony will be sworn. Participants, once sworn, remain under oath until we finish the hearing. We will begin with a synopsis of the application by the town building inspector, questions by the board, and identification of parties and those wishing to make a statement. Then we'll have presentation of the applicant's evidence with questions, cross-examinations, and an opportunity for applicant to present additional testimony. We will also then hear any statements from the public in favor of the application. I would ask at this time, is there anyone present wishing to make a statement in support of the application? Okay, please be advised that you should approach the table at the rear of the hearing room and provide your name and the fact that you wish to make a statement in support. We'll then have presentation of any opponent's evidence with questions, cross-examination, and an opportunity for opponents to present additional testimony. Statements from members of the public opposing the application. Is there anyone present wishing to make a statement in opposition to the application? If so, please raise your hand. I see none. At the close of all giving of evidence and public statements, the applicant may give rebuttal evidence, followed by closing argument. Finally, the board will deliberate and may vote if we finish deliberations today. However, such a vote is only to be considered part of preliminary deliberations. The final decision approved by a majority of the board is the official position and decision of the board. Appeals to Superior Court must be made within 30 days of the filing of the decision with the town. Susan, could you present your synopsis of the application, please?
This is Board of Adjustment 2024, Case 1 for 867 Garfield Parkway, Lot 4, Block 33, for C&J Cole LLC. The property owner, C&J Cole LLC, is requesting a variance from Chapter 425 zoning, Section 425-2, from the definition for a planned residential development, PRD. More specifically, the applicant is requesting that the requirement for a PRD to contain a minimum of 50,000 square feet be waived so that they can proceed with plans for development of a 3-unit PRD on a lot containing 42,535 square feet. The lot is approximately 7,465 square feet smaller than the required size. The applicant needs a variance to proceed to submitting for sketch plan review to the Planning and Zoning Commission. Zoning requirements for R2 residential district. The residential zone R2 requires the minimum lot area per single dwelling unit to be 7,000 square feet and 5,000 square feet for single units joined by a common wall. The minimum street frontage is 60 square feet minimum for a single dwelling unit and 40 feet per dwelling unit for a multi-dwelling unit. The maximum lot coverage is 40% for both types of units. The setbacks for single dwelling units are 20 feet front, 15 feet rear, and 7 feet each side. For single dwelling units, the setbacks are the same for a multi-unit building, except the side yards, which must be 7 feet times the number of units each side. Definition for a planned residential development. A lot improved or to be improved by 2 or more principal buildings without interior lot lines and with or without a public street or streets, which A, contains 50,000 square feet or more of land, or B, as of October 15th, 2004, was owned of record as a single lot containing less than 50,000 square feet of land, or C, consists of 2 or more abutting lots intended to be combined into one single lot, which abutting lots were, as of October 15th, 2004, owned of record by the same legal entity and cumulatively contained less than 50,000 square feet of land. The proposed PRD does not meet the requirements of either A or B, and C is not an option. History of ownership and improvements to date. The property known as 867 Garfield Parkway was purchased by the applicant in 2012. After purchasing, the applicant acquired a large dwelling located at 314 Second Street and moved it to approximately the center of the site. The property owners of 314 Second Street were having the dwelling moved in order to build a new larger dwelling. Lot description. The property at 867 Garfield Parkway is zoned R2 residential, consists of, excuse me one second. That must be I think there's an error there. It consists of 42,000, and I think I have 535 square feet, or has 103.196 linear feet of frontage on Garfield Parkway, 392.52 feet deep on the west side, and 429.19 feet deep on the east side. Improvements include a gravel driveway, 1 single dwelling, and a shed. The lot contains approximately 11,227 square feet of wetlands at the rear of the lot. The lot also contains a sewer easement on the west side and 3 existing sewer laterals across the site. Proposed planned residential development. The proposed site plan shows the addition of a 2-unit structure to be located some distance behind the existing dwelling. The plan is confusing as to what is gravel, what is parking, and what is an asphalt road. The plan shows the existing driveway as remaining gravel by how it is hatched on the plan, but a note states that they are proposing an asphalt street. The plan does not address the extent of the asphalt street or how the 2-unit structure fronts on it. The plan also calls for a proposed gravel driveway and parking for the 2-unit structure. Chapter 410, subdivision of land, also contains the same definition for a PRD and a list of required improvements. The requirements are issues that will or would be addressed by the Planning and Zoning Commission at the informal sketch plan review stage. And you should have received the copy of section 425-2 definition, a copy of the elevation certificate, copy of emails between the applicant and myself, the application, a written description of variance requested by the applicant, list of property owners within 200 feet, copy of the existing and proposed site plan for the PRD, and there is an enlarged copy of the proposed PRD as well. Any questions?
Yes. Can you tell us what the current lot coverage is on this parcel?
I have not calculated that, no. It's well below the 40%.
It is well below the
Yes.
40%. And do you know what the lot coverage would be for each of the two new lots?
The two new dwelling
Yes.
units? Let me take a look. I did not bring a calculator. No, I do not.
Okay. Did the applicant submit enough detail about the proposed dwellings to enable you to calculate that?
The only thing submitted for this application are the plans, the site plans that I sent to you.
Okay. And those do not enable you to make that calculation?
No, they do not.
All right. The existing lot has 103.196 linear feet of street frontage. Does section 425-56 require 40 feet per each of the new dwelling units and the existing dwelling unit?
425 dash.
I have it here if it would be helpful.
It does, but because they don't show exactly, it's not the frontage per se on Garfield Parkway. It'll be, they'll need to develop a private way or road that goes and connects them. Whether it has frontage is not clear on the plan that they have submitted. That would be something that they're not asking for any variance from and would be required by the Planning Commission, I would think.
So, so in your view, it would be appropriate to act upon the requested variance and leave the determination of whether the street frontage requirement is satisfied to the Planning and Zoning Commission?
At this point, because that is all they've asked for, and the design of the final PRD is it may not be what they've given here. What they need to do is to first be granted the variance to even consider being allowed to do a PRD. They may need to redefine how this works so that they all are on a private way. I don't know if they'll do that or if it's possible, but yeah, I think that's something that comes up when they look at sketch plan review. They'll have to be much more defined on that.
All right. Since the side setbacks are 7 feet times the number of units, are the side setbacks on the proposed site plan adequate?
I believe they are.
All right. many other lots exist in Bethany, roughly, if you know? Presumably only in the R2 zoning district, that are large, but under 50,000, and I would say over 40, but under 50.
That are currently developed or undeveloped?
Undeveloped.
I believe there are some large lots along Garfield Parkway. I know of one where it's, I think, 1 or 2 lots up from this that years ago, still owned by the same family, and years ago was granted a PRD, but somehow failed to proceed with it. The one adjacent to this one was granted a PRD, less than 50,000 square feet. They spent a long time going through the process, were granted it, failed to complete the project as well, and are now building a single-family home. But I think there's 1 or 2 possibly up Garfield Parkway.
The adjacent property you mentioned, it was under 50,000. Did it qualify under the date of acquisition
Yes,
standard?
I'm sorry, yes. It was owned by the same owner for a very long time prior to the ordinance taking effect.
Okay. Are you aware of any prior situation where a property acquired after October 2014 or 2004, under 50,000 square feet that has been granted a variance from that standard?
No.
Has the town received any communications from town residents opposing the requested variance?
No.
Okay. Thank you. Shirley?
Thank you, Mike. Before we begin, I'd like to add to the record, as Mike previously said, I live in Lake Bethany, and I believe I can render an objective decision in this case. Thank you. In excuse me, thank you. In the exchange of emails, there was use of the term PRD and master, what was it? Major subdivision. Are they synonymous?
No. And I originally was sending the emails in. I thought I wasn't going to because I thought they might be confusing. The engineer had originally sent me drawings and was considering doing a major subdivision, or because of the number of lots, it could be minor or major. And when we went through what would be required for that, they then decided to look at doing a PRD instead. In a major subdivision, you cannot put in a private way. You have to put in all of the improvements, such as 50 foot of right-of-way for a street that meets the requirements of the town, et cetera, et cetera. So there's other requirements with a major subdivision that are not required under a PRD. Also, a major subdivision has interior lot lines, and a PRD does not.
Okay. Thank you. Does the size of this lot, the 42,500, does that include with the wetlands in the rear?
Yes.
Thank you.
Okay.
No question.
Susan, a question on the rear setback, the way it's laid out. Is it correct? And where the dwelling will sit, is there enough rear setback? And it's not, there's no variance required for that, correct?
There's a huge rear setback. It's not to the edge of the wetlands, it's to the edge of the property line.
It is?
Yeah.
It is, okay, I see. So it includes the wetlands?
Yep.
Okay, thank you.
Okay, with no further questions, for Susan, we will move on. And I would ask, Mr. Plitko to approach the
Good morning. As I stated before, my name is Ray Blakeney. I work with Plitko Engineering. We're at 53 Atlantic Avenue in Ocean View. I'm here with two of the owners of the property, Charlie and George Cole. They're available to answer any questions you may have, as well as what I have. The Coles, as Susan said, the Coles bought the property in 2012 and had a house moved from 2nd Street to the property. The existing property, again, as Susan mentioned, has an area of non-tidal wetlands at the rear of the property. And there's an existing sewer and water easement along the edges of the front of the property, as well as existing sewer lines that run sort of diagonal through the front of the property. What's not shown on our plan is the fact that those sewer lines are in a sewer easement. At the time we prepared the plan, we weren't able to confirm that, but we have since confirmed it. I do have an exhibit here I can enter into the record if you'd like, that shows that sewer easement and notes that it was recorded in Deed Book 4179, page 72.
yes, if you would approach, we'd be happy to. Thank you.
So that's important to note, that there is an existing sewer easement that runs here, and that spoke to where the original house was placed. It's placed in the back, adjacent to that sewer easement, but obviously not on it. But that's why the existing building is set back so far from the street. The lot, as Susan mentioned, is very large for a typical lot in the R2 district. It's very large for a single-family home. And as Susan mentioned, it's probably one of the last lots in the town that are this size. There's an existing lot, well, I can show that later. Also, as Susan mentioned, we initially looked at this as a major subdivision. With Susan's recommendations, we realized that putting in a town street with a cul-de-sac or a fire department turnaround, as well as trying to get lot lines in here, was going to be very difficult, if not impossible. The paved street and the cul-de-sac themselves would take up, a very large portion of the property, and add much more impervious surface to the property as well. Even if that were done, the lot geometry itself, with a long, relatively narrow lot, is not really conducive to a major subdivision. The proposed lots would likely be oddly shaped if they could even be made to conform to town standards. Likely what would happen is the owner would then be back in front of you requesting a variance on the lot dimensions or the setbacks in order to make a major subdivision work. Instead, what we did was we looked at the planned residential development. In our view, This plan meets all the criteria, or could be made to meet all the criteria of a planned residential development, with the exception of that 50,000 square foot overall lot size. This parcel, as Susan said, is short of that requirement by 7,465 feet, approximately, square feet. But otherwise, we feel it's tailor-made for a planned residential development, and it would certainly make much more sense to develop it that way, both from a visual and from an environmental perspective. If allowed, the net density of the proposed PRD would be approximately 4.17 dwelling units per acre, or 10,436 square feet per lot, which is well in excess of the requirements of the R2 district. This is the property here. There are several other planned residential developments along Garfield Parkway. My firm, Plitko Engineering, and my previous firm, Land Design, were involved with several of these PRDs, so I can speak to them with some authority. Most, if not all, of the PRDs along this stretch of road have a higher density than what's being proposed here. With the town's oversight, all of these projects turned out well. We believe they're an asset to the town, and if this variance is granted, the town will again have input into the project as it develops through the site plan approval process. As Susan mentioned, there is a lot to the east that was recently subdivided into two even more narrow lots that I believe they're going to be building single-family homes on. This lot to the west, I believe, maybe the one that Susan was referring to that had a PRD approved. I don't know what the status of that is. I do have a picture of the proposed PRD, but I'm not sure how old or how accurate it is. But in summary, like I said, we believe that given that the owner has a right to develop his property to its best and highest use, and he wants to add 2 units, again, that they're going to keep in the family, we believe that a PRD would definitely be the way to go as far as less impact visually and environmentally, and also meeting the criteria of the town to the best of our ability. I'm willing to answer any questions you may have, as are the owners. Thank you. Do you want to speak? Yep, sure.
Back in 2012,
Excuse
George
me.
Cole, for the record.
Mr. Cole, good to see you. Please state your full name, your local address.
All right, it's George B. Cole, and I live at 29271 Woods Edge Drive in Ocean View. I'm also, for a couple of you guys know me, but I have the antique shop that used to be down the end of the street there, who a couple of their wives used to come quite often. And it's no longer there, of course, and my sons have pretty much taken over that too, my two older boys. So I have 2 younger boys who are in the Merchant Marines, and you know how expensive it is to get to live in in Bethany Beach and Rehoboth. So anyway,
Yeah.
with this
Excuse me,
property
George,
in the size,
if I may,
go ahead.
I need to swear you in.
Oh, you do? Will I come
No,
over to
stay
you?
right there. Do you swear or affirm to tell the truth in this hearing?
Yes, I do.
I'm sorry, I should have been faster with that.
That-
Please proceed.
That's be fine. Anyway, so back to where my 2 younger boys are Merchant Marines, and again, the cost of living in Bethany Beach, we've been here a long time. And, you know, for my sons to have a presence in Bethany Beach, this is a great opportunity. And I feel that what we're proposing with a duplex in the back of this large lot, as you can see how large it is basically a hardship if I'm just restricted to one single-family home. And I think that is what the current ordinance would require me to just have one home, which I have there in the front. That used to be on 2nd Street. I purchased that house for $1, and it's probably one of the best investments I made. After that, it got expensive when I moved it. But anyway, I had to run around town. It was a 2-story house, and to move it, you had to be close by. So I found this property. It had been in an estate for quite a few years, and it was the last piece of property they had. So I was able to buy that, and I was forced to put the house back because of the sewer easement, which is fine because I think it looks very nice sitting back, and I think it's the best place for it because if I'd have put it closer to the road, the impact of Route 26 nowadays would have been much more dramatic. So By doing that, and we've had it now since 2012, I actually rent the house. Susan was involved when I moved it all in there and everything. So that's kind of the feel we have. I don't think it's going to have any impact. I talked to this gentleman just the other day. He was cutting his grass. He has no problem with it. And I believe he was approved for 4 units. Jody here on the other side was approved a couple years back for, I think, 5 units. And then she got in a disagreement with her builder or something. The next thing you know, it all fell apart. But this commission had approved 5 units over here. So my petition for 3 units I don't think is out of the ordinary. I don't think it's going to have any impact on Route 26 because you've got multifamily units all up and down there. This will sit back, being that it's a duplex, it'll have the appearance maybe of one single family home, be it a large one, but I don't think it'll distract. It's got a great buffer from the community in the back here with this setback, plus there's wetlands on each side of it. So if you have any questions, I mean, that's pretty much it. We think that it's not going to have any, like I say, negative impact to the town. It'll be a benefit because of you're going to have 2 more places to put on your tax rolls. And in the major subdivision, as he talked about, to put 50 foot in here, it'd be ridiculous to make this a major subdivision just for a duplex. So I thought that was overkill, and I felt that this was the best approach for it. So that's all of my presentation, but thank you.
Thank you. Mr. Plitka, if you would, please return to. In the application, there are several items that are drawn from the town code. The first being that there are extraordinary and exceptional conditions pertaining to the particular lot or structure in question because of its size, shape, or topography. And in the application itself, the response to that is essentially that the lot is very large. Is there any other element of the conditions that you consider extraordinary and exceptional other than the size?
Sure. As we stated previously, besides the size itself, it is actually relatively narrow relative to its size, which makes, as we stated, putting it in a town street very difficult, if not impossible. We have the existing sewer easement along the front and the west and the rear, which really restricts the developable area to sort of this center rear portion of the property. So I would say those 2 elements as well, in addition to the size of the lot, would be the major hurdles to developing this strictly within the town's requirements, without a variance.
All right. Understanding that you are seeking a variance in order to proceed with the Planning and Zoning Commission to satisfy the requirements of the provisions of the code that they're administering. Do you, at this time, know how you intend to satisfy the minimum street frontage requirement of the code?
At this time, no. We haven't really looked at that in detail, other than looking at the street frontage of the lot in total. That would be, again, something we would work out as we develop these plans more fully in anticipation of submitting them to the town, the Planning Commission, as part of a PRD application.
But you do understand that that body would not have jurisdiction over a waiver of the minimum street frontage requirements,
Yes,
so that if you're unable to work it out, you would have to come back
that's correct.
again.
Yes, that's correct.
All right. I have no further questions.
Thank you, Mike. A couple of questions. I'm not sure who to direct this to, whether Ms. Susan or yourself. So there will be a street on the left side of the lot?
Yes.
Um,
Not a street technically, an access, a driveway. Not a town street per se.
So what about the public works, trash collection, things like that?
We would provide a place for trash collection, we provide an area for turnaround of municipal trash trucks as part of the site plan for the PRD.
I've heard what you said. I didn't understand. Looking at this,
There's an access road, there's an access here, then we're going to continue back to the proposed units in the rear. Trash collection would be, I'm assuming, roll-out units. We got to be able to we designed the drive in such a way that the trash truck would come back here, pick up the trash, turn around, and be able to exit the same way they came in.
what about things such as ambulances, fire trucks, and should that become necessary?
They would have access in. We'd have to meet the requirements of the fire marshal. When we prepare, as part of the PRD regulatory approvals, we'd prepare a fire marshal site plan that they would review and approve. So we would leave that up. We would work that out with the fire marshal. I don't think what we're proposing is very different than other developments that have been built along this area. And the fire marshal has signed off on them as well.
So that's not a public street then?
It's not a public street. If it's a PRD, it will not be a public street.
Right, I think we went through this with another property, but we have public streets or we have what's called private ways. And so this would have to meet the requirements of a private way. It would still have to have the requirements approved by the fire marshal and the Planning and Zoning Commission for access by our public works, fire trucks, all necessary
Okay. So
traffic.
I believe you said it would be a narrow area, given the dimensions of the lot. But it's not a public street.
Correct. It is not a public street.
Okay. Thank you.
Sure.
The street or the entrance off of Garfield Parkway of Bethany Trace, which is the last development up, before you get into Lake Bethany. In looking at that, it looks very similar to this situation. Is that a public street or a public way or what?
I would believe that that's a public way. A public street has to have, I believe, a 50-foot right-of-way. And a certain area of that is paved, and it's paved to all the requirements of the state code. It's not the same as a private way. A private way was what was approved for the Onifray property adjacent to this, which had one road going in And all the houses were fronting on that road, giving them all frontage. And that's where they actually had all their drainage being done as well, the way that they had designed it. I don't know how some of these others were designed, but they evidently were approved by, at some point, the fire marshal.
Yeah, and that same thing, the Bethany Trace, I think there are 5 units, 4 front units, and then a larger house in the back. And have you any idea what the lot coverage of that area, and whether it was required that they have a variance at the time it was made?
I'm pretty sure there was no variance. It was probably built before this code, when multiple units on a property were permitted in lots of cases, and I think that's the reason for the code. How this got approved and what the requirements for lot coverage or their driveway, their right-of-way, I don't know. I don't know how they used to do that.
Okay, and last question, is all of this sewage underground coverage that does not permit them to build in certain areas of the lot, is that highly unusual for the lots basically all along Garfield Parkway, or?
I don't know. It's not common to have all these, a sewer easement cross diagonally across a lot. But in this case, they have that.
Thank you.
Jack, I can answer that if you want.
If you please approach the,
The sewer easement is diagonally across that lot. Why? Is because when the engineers for the county, back when they were laying it down Route 26, somebody decided that if they cut the diagonal across that lot, they would get over to that manhole that then shoots and avoids the bridge. Nowadays, they would go under the bridge, but in the old days, they tried to avoid that bridge. So they had an easement, the county had an easement between down this property, this property line on the west side. They had an easement to that manhole, and it was supposed to come down, go up here, and then across. Somebody wasn't watching the ball, and the guys got here, and they said, look, it's quicker if we went this way. So it was a vacant lot, and I think the owner was kind of absentee or whatever, wasn't aware of it, and then that's occurred. So it was on the county's kind of stack of things that they needed to address because the easement was in the wrong place. So when I purchased the property, we created a new easement, and all the sewer from North Bethany, all through Bethany, everything goes to this pump station, goes down, goes under that property, and then under the canal, but back away. So it was just a mistake. Nobody caught it. It forced me to put that house back, which again is I'm glad I did, but that's basically why it's there. And then I created that large easement across this whole like pie-shaped area here is now an easement, can't be built on. So this will always be open in the front. You always have that nice grass, and the buildings will be in the back.
thank you.
Thank you. That's all I have.
Yeah, earlier it was mentioned, and I don't know who, that this is one of the last lots of this size. And I just want to understand the basis of that. How do we know?
How do we know how many large lots we have left?
Yeah.
Well, I could bring in a general map of the area and show you. We have, I know, several up Garfield Parkway. We had 2 really large lots on Kent, and they got cut up, and the subdivision for that didn't go through. So they're privately owned now, and single-family homes are on them. I can't think of another area where I have bought Walczek's property, so that's no longer in play as a large lot. So I can't think of any other area that would have a large lot.
Okay.
They're all sort of, west of Route 1, they're all developments. We have Bethany West, we have Turtle Walk, we have Lake Bethany. So they're all, other than some of those along Garfield, I don't think there are any others
Okay.
that I'm
That's
aware
helpful.
of.
Thank you. That's all.
have no further questions at this point. We do have someone who expressed an interest in speaking.
She actually wants to wait for 613 Fifth Street.
Okay.
I want to amend what I just said. There is one other large lot on the opposite side of the street, right after the entrance into Bethany West. But they've divided it into 2 lots, and it will go forward with a duplex or something.
Okay. Thank you.
Anything else?
Not at this time, thank you.
Well, we want to give you an opportunity to make whatever closing statement you would like.
I think we've covered everything. Like I said, the main gist is that there are some restrictions on the property with the sewer easement and the wetlands in the rear. And we've discussed with Susan the idea of looking at a major subdivision, and it really was a mess. So it certainly seems to us that a PRD is the way forward. The owner's not trying to maximize the site. He basically just wants to build some homes that they can keep in their family. And again, we feel that the PRD is the sort of the path of least resistance, the way to really get that done. And what we would create would fit in with what has already been built in the town and would actually be an asset to the town. And that's really all I have.
Thank you very much.
Thank you.
With that, we're going to close the hearing, and we're going to take a 5-minute break before we deliberate. Thank you.
is here now, and it's got all the sewer stuff up here. And then he has an entrance here already going to this and his turnaround and driveway. But there's nothing back here. Well, I guess there's a shed there now. But it's the idea that that would be it would go along the side of his property, but would be within the, it would be, all three would have to get in this one way. And it can't be a street, it's gotta be a private, whatever. And, then like she mentioned, the trash company and everybody else, the fire company will have to make sure that access to all of these is good, so. Well, I would guess. They got a lot of room here that they can put a turnaround on that they can't build on because of these sewer lines. And so, a fire truck, they can park anywhere along here, but what he was talking about was you'd come in the driveway, and then you could back into here with a trash truck, pick up the trash, back here, and then go out the same way. We're gonna have to get back on the record. All right, back on the record.
Thank you. Yes, sir.
So long, Andy. Oh, don't worry about it. Yeah. They are neighbors. They live on Lakeview and back up to the area.
At this time, we're going to reopen the hearing for the board to deliberate. As chair of the board, and in accordance with the board's custom, I will proceed first in our deliberations to review the legal standards we apply in deciding applications for dimensional variances and to offer my initial views. We will then hear from each of the other board members in order of seniority. The applicant seeks a waiver of the 50,000 square feet minimum lot size contained in the definition of a planned residential development in section 425-2. The applicant's lot contains 42,535 square feet. This same definition of planned residential development is contained in section 410-6 of chapter 410 subdivision of land. Section 410-31 allows the Planning and Zoning Commission under certain circumstances to vary or waive the requirements of certain sections of Chapter 410. Section 410-6 is not among those provisions. Section 425-105 of the code authorizes this board to grant variances, quote, from the dimensional terms of this chapter, close quote. I view the 50,000 square feet standard in section 425-2A to be a dimensional term of this chapter. The board therefore has authority to grant a waiver under section 105D1 that, quote, will not be contrary to the real intent, where owing to special conditions, a literal enforcement would result in an unnecessary hardship or exceptional practical difficulties. Under that provision, approval of a variance requires that the board find 4 specific standards are met. The first is extraordinary and exceptional conditions pertaining to the particular lot or structure in question because of its size, shape, or topography. Applicant maintains that the details of the lot in question do present extraordinary and exceptional condition. They note the large size of the property, over 42,000 square feet, 11,227 square feet of which are wetlands, and with sewer line easements running across the front portion of the lot, which also restricts its use. It does appear to me that there is merit to their position. The lot is certainly very large in comparison to the typical Bethany Beach lot. It is also unusual in that it appears that there are very few lots that might be this large, but not large enough to satisfy the 50,000 square foot standard of Section 425-2 of the code. I also note that at the time the 50,000 square foot standard was adopted, the legislation allowed smaller parcels to qualify depending upon when they were acquired, i.e. pre-October 15, 2004. Although this property does not qualify based upon when it was acquired, i.e. 2012, the code's allowance of some parcels less than 50,000 square feet, if acquired pre-10/15/04, is worthy of note in the context of this matter, if only as an indication that the 50,000 minimum was not considered absolute at the time it was adopted. The second element is application of the code to this particular lot or structure. It would create an injustice. Applicant contends that the site meets all other criteria for a 3-unit PRD. In fact, it is not apparent to me that all of the other criteria have been satisfied. The representation is that they will be satisfied before the Planning and Zoning Commission, if allowed to proceed to that step. With that caveat, it appears to me that it may be possible to meet the standards at the next stage. The applicant notes that there are similar developments in the neighborhood that were approved and constructed. For this reason, it argues that it would create an injustice to prevent it from being allowed to proceed with its proposed PRD. It also notes that it is not seeking to maximize the site density with its proposed plan. I do believe that considering all the circumstances preventing applicant from proceeding to the next stage of trying to qualify for a PRD would be an injustice. The third element is the conditions are peculiar to the particular piece of property involved. In the aggregate, the conditions relating to this property do appear to be peculiar, given its large size, the large percentage of wetlands, and the significant sewer easement restrictions it presents. The fourth element is that a variance, if granted, would not cause substantial detriment to the public good or impair the purpose or intent of the code. Applicant says that its proposed development is designed to fit in with the surrounding neighborhood. The proposed new duplex would be set back in the lot behind the existing home, would not affect the streetscape along Garfield Parkway. Given the size of the lot and the conformance of the new duplex to all the dimensional requirements, granting the requested waiver should not cause any significant detriment to the public good or the purpose or intent of the code. I consider it significant in this case that if the variance is granted, the proposed PRD is still subject to substantial review and approval of the Planning and Zoning Commission under Chapter 410 Subdivision of Land. It is also appropriate to note that there has been no opposition from neighboring property owners, and there is no indication that the variance would adversely impact them by adversely affecting their property values or in any other way. The board must also be mindful of the Delaware Supreme Court's holding in the Quick Check case that for an area variance, the focus is on the exceptional practical difficulties test and its articulation of 4 factors to be considered. The first is the nature of the zone in which the property lies. In this case, the variance is sought for construction of 2 new residences in a residential zone, so it appears that this standard is satisfied. The second element is the character of the immediate vicinity and the uses contained therein. It does appear that the variances sought here would allow construction of 2 new residences that would conform to the character of the immediate vicinity and uses. The third quick check element, whether if the setback restrictions were removed, that would seriously affect neighboring properties. It does not appear to me that the effect of granting the requested variance would significantly affect neighboring properties, as I noted earlier. And finally, Quick Check examines whether, if the restriction is not removed, it would create exceptional practical difficulty for the owner to make normal improvements. As I earlier noted, I do not believe that granting the proposed variance would seriously affect neighboring properties and uses. I think denial of the variance would create unnecessary hardship in relation to the owner's efforts to make normal improvements in the character of a permitted use of the property. Accordingly, in my view, the requested variance should be granted in order to allow the subject property to be treated as qualifying for a PRD. Sherwin.
Thank you, Mike. I'll be shorter. I consider the Bethany Town Code to be in place for a purpose. Those of us who live here have much to be grateful for that the town is the way it is because of the code. I consider, how much was it? 7,200 and some square feet to be significant. And this is the reduction below the 50,000 square foot. I consider that significant, and because the code dictates the 50,000 square feet, and I see no direct harm in not granting the variance. So considering that, without going through the 4 requirements, I am opposed to granting the variance.
Thank you. Jack?
As far as our requirements for changing or for going along with this request, It is an extraordinary lot. It's got that sewer below it. The house that's on it now was put there because of those various problems. And the size of the thing, and the nature of the whole area there. I think it would present a hardship if they could not make full value of the use of the lot. Conditions particular to this property, they couldn't make full use of the lot anyway. When I look at other lots as I go down the street there, right now it looks unusual in that you see the one house way back and just a lot of open lots. So it certainly wouldn't be detrimental to the area if in fact there were a couple dwellings added to the one dwelling that is on the lot right now. The nature of the zone is the same more or less that you see on Garfield Parkway in that area. Like character uses in the vicinity, it won't affect the neighborhood at all if in fact this were to happen, in my opinion. And it would definitely affect the owner's ability to use the property the way they want to, if not granted this change. So I believe that the variance should be granted based on just the way the area is developed in that area and the idea that it wouldn't affect the neighbors to any great extent, in my opinion. So I would go along with the application as requested.
Steve?
Thank you. I think I'll be shorter than my colleagues. I'm certain I will be. I did consider the criteria for which we must consider reviewing the variances to the request, and I am in favor of granting a waiver. This is a complicated lot with the sewer and the wetlands, and as we discussed, the size of the lot relative to what's also available in town. I do think there's other opportunities that neighbors have to develop, and it would be an injustice not to provide that opportunity to develop this lot. I am concerned about the next stage of what's required to meet the standards at the next stage. I think that's going to be a lot of work, but I see no reason to object to granting a variance. So again, I'm in favor.
Okay. Do we have a motion on the application?
I move that we accept the application as proposed by the applicant.
A second.
Second.
A second from Mr. Boyce. All those in favor, raise your hand. Aye.
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 Let the record show that we have 3 ayes. All those opposed? Let the record show we have 1 opposed. And accordingly, this is not a final decision. There will be a written decision. That written decision will constitute the final decision of the board. But the board action here is to grant the variance, and the details of that will be spelled out in the written decision. Thank you very much. We're going to take a short break at this point.
Stormwater's going to be in that area.
At this time, we would like to call to order our hearing in the second matter today. That's BOA 2024-2, 613 Fifth Street. This is a hearing of the Bethany Beach Board of Adjustments for the purpose of considering an application submitted by the property owners, Frank C. and Lauren M. Graybill. Did I pronounce that correctly? Graybill. For the property identified as Block 28, lots 80 and 81 at 613 Fifth Street in the R1 Residential Zoning District of Bethany Beach, Delaware. Applicants seek variances from Section 425 zoning, Section 425 Appendix 3, Table of Dimensional Requirements, Minimum Yard Depth, Rear. The application requests that the requirement for a minimum rear yard setback of 15 feet be reduced to 8.4 feet for an addition to be constructed on the left side of the existing dwelling, and to 6.3 feet for an elevated deck, pool, and pergola to be constructed to the right rear side of the existing dwelling. Let the record show that there are 4 members of the board present. Since each spoke their name earlier for the recording, that will not be necessary. We are again accompanied by Susan Frederick, the town's building inspector, and Ray Lean Menominee, the clerk of the board. The application and associated documents are part of the record and have been marked as applicants Exhibit 1. Susan,
Yes, sir.
do you swear or affirm to tell the truth during this hearing?
I do.
Did the town place a notice of this hearing in public places?
Yes, on March 14th, 2024.
And can you tell us where it was placed?
It was placed by Raylene Menominee at the, twice at the Boardwalk, Town Hall, the library, and the post office,
All right. And did the town cause a copy of the notice to be published?
The notice was published in the Wave newspaper on March 19th, 2024, and on the Coastal Point, March 15th, 2024.
And did the town cause to be mailed by first-class mail addressed to property owners within 200 feet of the subject property a copy of the information required to be posted?
Yes, notice by mail was done March 14th, 2024.
And did the town place a notice of this hearing on the property at 613 Fifth Street?
Yes, notice was posted on the property on March 14th, 2024.
In the absence of objection, I find that notice of this meeting has been posted, published, and mailed consistent with Section 425, Part 107 of the Code. I'm not going to go through the procedure we're going to follow here because we did that earlier, and you heard that. So we will begin with a synopsis by the town building inspector.
This is Board of Adjustment 2024, case 2, for 613 Fifth Street, Block 28, lots 80 and 81, owned by Frank C. and Lauren M. Graybill. Property owners, Frank C. and Lauren M. Graybill, are seeking variances for property identified as Block 28, lots 80 and 81, having the address of 613 Fifth Street, from Chapter 425, Appendix 3, Table of Dimensional Requirements, Minimum Rear Yard Depth. The applicants are requesting that the rear yard requirement be reduced from the required size of 15 feet to 8.4 feet for an addition to be located on the left side of the existing dwelling and to 6.3 feet on the right side of the existing dwelling for an elevated deck, pool, and pergola. Lot description and improvements. The property is located in the R1 residential district. It consists of 2 lots that were combined at some point with a total area of 11,693 square feet. The required setbacks are 20 feet front, 15 feet rear, and 7 feet each side. The property is the last property fronting on Fifth Street and the canal on the east side. The lot is improved with a 1.5-story dwelling and an elevated deck, shell driveway, and parking area, a dock, and a shed. Proposed additions. The applicants are requesting variances from the rear setback for the following. 1, a proposed addition to the existing dwelling that will be connected by an enclosed hallway. No plans or elevations for the proposed addition have been submitted. Ray Blakeney from Engineering from Plitco, who developed the site plan submitted, has stated that the addition will be for an office and 3rd bedroom. 2, a proposed elevated deck, pool, and pergola to be located on the east side to the rear of the existing dwelling. The elevated deck will align with an existing deck. I do not know the actual height of the deck, but it exceeds 12 inches from grade and is considered a structure. The proposed pergola will be either the existing one that they show in the submitted photos or one similar. Definitions. The following definitions from Section 425.2 support the determinations for what is considered a structure and what is the rear yard for determining what is not permitted in a rear yard. Structure is that which is built or constructed, an edifice or building of any kind or any piece of work artificially built up or composed of parts joined together in some manner. The term structure shall be construed as if followed by the words or part thereof. Rear yard, the required open space located in the rear area of a lot or plot. Additionally, in Appendix 3, Table of Dimensional Requirements, footnote A, to maximum lot coverage by buildings, states that it is to include principal and accessory buildings. Coverage is the maximum horizontal cross-section areas of buildings on a lot, including covered arches and open deck porches built more than 12 inches above the ground, measured from the ground immediately below to the top of the finished floor, but excluding cornices, eaves, gutters, and chimneys, and any of the following where the topmost finished surface is less than 12 inches above the ground, measured from the ground. Outside steps, open deck, porches, patios, walkways, or driveways. The pool. The regulations for private pools are found in Chapter 500, more specifically Section 500-3. I had concerns regarding whether the Board of Adjustment could grant a variance for the dimensional setbacks for a pool. Section 425-105, Powers and Duties, D, variants state that the board has the power to authorize upon appeal in specific cases such variances from the dimensional terms of this chapter as will not be contrary to the real intent where, owing to special conditions, a literal enforcement of the provisions of this chapter would result in an unnecessary hardship or exceptional practical difficulties. I requested Mary Schreider Fox, attorney for the board, to review the matter. She determined that since the setbacks for a private pool found in Section 500-3 state that a pool is required to be so located that the distance from the water's edge to the side and rear lot line is not less than the building's setback line as required by Chapter 4, it should be 425 zoning. My numbers got mixed up there. The board could review and determine the matter. Her email on the subject was attached for more details. Additionally, as elevated, the pool would also be considered a structure. And what I attached for you was a copy of Appendix 3, Table of Dimensional Requirements, a copy of Chapter 500, Section 500-3 with regard to pools, Copies of emails between the applicant and myself, copy of the email from Mary Schreider Fox, the transmittal from Plitco Engineering, the application and attached written description of the variance, site plan, 2 site plans, list of property owners within 200 feet, support letters, and photos of the existing dwelling and deck. Any questions?
Yes. With the site plan, and I'm looking at the version that has just this lot on it. Well, I should say, it has only one.
Which,
Yeah,
okay,
it's both
that is
lots.
the one with the additions proposed.
Yeah,
Okay.
the previous page has 2 separate, they're both the same, but I'm on the one with only one depiction of the lot.
Okay.
Did you calculate the existing lot coverage?
I did not.
Are you of the view that it is less than or no greater than the maximum coverage?
From just visually, I would say it probably will meet the code for lot coverage.
And when you say that, are you referring to the addition as well and the pool?
Yes.
All right. On the pool itself, because Section 500-3 A2 requires that the distance from the water's edge, that's the edge of the water in the pool, correct? It seems clear from this that it looks like it's underneath the lattice is where the water would be. Is that correct? In other words, you see the pool, the dark line for the pool runs under
Yes.
the lattice, and that dark line would represent the edge of the water.
Yes.
So it seems clear that that's less than the required setback for a rear yard.
Yes.
Okay. Did you consider whether a variance of section 500-3A2 would also be required?
That was my question to the attorney, because the way that I have to go back to my notes. The way that it is written in our code, the Board of Adjustment can give dimensional variances to that section, 425.
425, correct.
She stated that because Chapter 500 referenced back to the setbacks in that 425, that yes, you could review this matter based on that, but not reviewing it under Chapter 500. That's my understanding.
So, as I understand what you're saying, we can review it because it is incorporated, 425 is incorporated by reference in section 500.
Yes.
But if we grant a variance under 425 with regard to the rear yard, did she opine as to whether that would automatically be considered effective under 500-3A2?
Yes, my understanding is that 500 says the pool's edge cannot be in the rear setback. So if you set the rear setback in 425 as a variance, that applies.
Okay, I think that there's another interpretation that could be applied in that circumstance, but we'll proceed on that basis.
Thought I put that in here.
The applicant's site plan has a note stating that the hallway between the existing house and the new addition was located to avoid interference with a picture window on the house. We'll have an opportunity to inquire about that, but do you know where the picture window is?
I do not.
Okay. It appears that if the addition were moved forward to the front face of the existing house, the rear of the addition might be inside the 15 feet rear setback.
Yes,
Is that correct?
yes.
And would that entail any impact on existing landscaping on that side of the house?
I don't know.
Okay. All right. I don't have any other questions. Sure.
Susan, the proposed building addition, building expansion, does the town need more specifics about what is planned in here for the expansion?
Not for this purpose. The only issue that I raised with the engineer was that it be connected with a conditioned space, it's not a separate building. It can't just have a open walkway to it. It has to be connected. And once they do that, we can take a look when they develop it, what the plan will be for it. As far as I know now, it's a bedroom and an office.
Right, right. Yeah, there were no doors, the only entrance is through that hallway.
I don't have any plans for how this will actually work yet.
Okay. Thank you. Okay, is the 4 foot, so if that hallway should fall down, will the, yeah, but if, should it be disconnected in some way, does the building need the expansion? I'm calling it a building. It seems so independent to me.
It did to me too, which is why we clarified how that hallway works. It shows, and at this point, it shows it is elevated to the same level as the existing building. So if the hallway fell down, there'd be no way to get into it, because there's no stairs shown. It's only accessible through that hallway.
Okay. Thank you, Susan.
And no question.
Steve?
No questions? Up, Susan.
Thank you, Susan. Mr. Plitko? You've already been sworn once, but since this is a different hearing, do you swear or affirm to tell the truth during this hearing?
I do.
Thank you. Please
Um,
proceed.
For the record, my name is Ray Blakeney. I'm with Plitko Engineering. We're at 53 Atlantic Avenue in Ocean View. I'm here with the owners of the property, Frank and Lauren Graybeal. They're available to answer any questions you may have about the property or their purchase of it as we move forward. As Susan stated, the owners are applying for a variance to the rear yard setbacks to construct a building addition to their home and to expand their rear deck to install a small plunge pool. I won't spend too much time on the existing site. Susan did a good job of describing what's there. The lot, as Susan said, was probably at one point a double lot. There is currently the existing structure in the center of those, well, again, it's one lot now, so there's an existing structure in the center of the lot. There's a small horseshoe shell driveway and parking area. There's extensive landscaping around the site. There's a lawn area that goes around. There's an existing shed in the northwest corner of the property and a small existing dock or kayak launch on the canal. Let's see. I do want to note that the landscaping that we're showing on our plans is illustrative. It's not reflective of what's there. If we were to move forward with the project, we would do a more serious landscape inventory. But there is some landscaping you'll see in the pictures. There is existing landscaping along the rear and side property line that help to screen the adjacent properties. The Graybeals purchased this property in 2017. At the time, the cottage house that currently exists there was at grade level. The Graybeals raised that up in 2019 to get it out of the flood elevation. The owners have also improved the decking, the windows and the roof of the house, and they've, as I mentioned, landscaped the property. They've done extensive interior remodeling, and the existing house, as it stands right now, currently has 2 bedrooms. This house is their primary residence. Mr. Graybeal often works from home as well. So right now, the kitchen table acts as his office. The proposed 1-story addition would add a 3rd bedroom to the home, as well as an office for Mr. Graybeal, and a small utility room to house their washer and dryer, which is currently in a closet. The owners also wish to expand their deck, as Susan stated, to add a small plunge pool of approximately 12.5 feet by 18 feet. As part of this expansion, they would construct a pergola structure similar to what now exists to help screen the views from the north. So this is the front view of the existing cottage. You can see how it's raised up on a foundation. I believe you have a copy of this picture. This picture here shows the side of the house, the west side of the house where the addition would attach. And this is the picture window we were describing. So that 4-foot hallway that we described would be in this area somewhere. Once building plans were prepared, we'd have a better idea of how that's going to connect with the existing house. The hallway will be also on a foundation, so it's not likely that it's going to fall down. It's going to have a structure, it's going to match the house as far as the foundation and the connection, as well as the exterior materials.
Excuse me.
Yes.
The second picture you referred to,
This picture here.
correct, the one in the center at the top of that. We do not have a picture of that.
Okay.
It is not in evidence.
Okay.
So please provide us a copy of that. Is there anything else on that exhibit?
You have, I don't think you have a picture of this. This is showing sort of the rear, this area here, I guess on the existing, showing the existing deck and the rear property line, and that pergola structure that's here. And I can provide you with this photo as well.
All right,
It's just showing you the area that would be, where the deck would be expanded if the variance were granted.
okay. Do you have copies of those available now?
I do, I can email them to you. I do not think I have copies with me. I do have a copy of that shows the deck in a very similar view. I do not have a copy of the side of the house, but I can provide them to you today.
All right, well, the members of the board may want to take a closer look, but please proceed.
Okay, thank you. Yes, so we talked about expanding the deck for the plunge pool and the pergola structure, as I said, similar to what the existing site conditions somewhat limit what the Graybeals can do with their property. The building addition is proposed on the west side of the house, as we're showing it, because given the interior flow of the house, the west side is more of the private rooms of the house. The east side are more of the public rooms of the kitchen, a sitting area, the deck, and everything. So it makes more sense to put a bedroom and an office on the west side rather than the east side, given the flow of the home. The reason that we put the addition where it is they wanted to keep the front of this addition basically even with the main plane of the front of the house. This area here in the front is really more of an enclosed front porch. The main plane of the home is here, and they felt that by siting this here, it would give the building more of an architectural balance. And that's why we didn't slide it forward out of the rear setback. This building this addition is roughly sized to what they think they would need, again, to do that third bedroom, a small office, and a small utility room that they're
Excuse me.
proposing. Yes.
When you say roughly sized,
Yes, we haven't prepared any building plans at this point.
are the dimensions going to be the same?
Yes, they would have to be. I would assume if you're going to approve it that way, that they would have to be the same.
And do we have those dimensions on the,
Yes, the addition is approximately 18 and a half feet wide, and it is 48 and a third feet deep from the front corner to the rear. The owners are, let's see, relative to this hallway that we're discussing, the reason they're proposing that connection in the way that they are is to, again, minimize disturbance to the existing house, the existing wall. Rather than take out an entire wall, they basically want to just sort of punch through that hallway to the addition. But make no mistake, this is an addition to their home. It's not going to be a separate structure. I think it's also worth pointing out that the off-site views in this northwest corner are basically looking back at a shed on this property and a shed on this property to the east or to the west. So we don't feel that this addition and this encroachment into the rear setback is going to affect the neighbor's view of the property. We talked about the deck. They want to expand the deck to the rear of the site because they want to preserve the existing buffer between the house and the canal. They really would prefer not to build any further east on the property than they already have, again, to sort of minimize any disturbance to the canal. The owners are sensitive to the impacts of their proposal. They've limited their proposed variances to the rear yard setback to minimize the visual impact from the street. They're not proposing any construction closer to the canal to help protect that waterway. They've also approached their immediate neighbors, all four of them, three to the rear, one to the west, with their proposal, and they've received letters of support from all four. It's also worth noting that should this variance be granted, the town would have input to the proposed additions as part of the site plan and building plan review process. I'm available to answer any questions, as are the owners.
I want to note that one of the conditions we look at under the code is whether there are extraordinary and exceptional conditions pertaining to the particular lot or structure in question because of its size, shape, or topography. Now, topography is not defined in the code itself, but it is typically defined as the arrangement of the natural and artificial physical features of an area. So it does include natural and physical features of the area, and I would guess that would encompass landscaping. So the position of the addition being protruding into the rear setback does create more room, obviously, to the front of that. As I look at this site plan, it looks to me like if you were to slide it forward so that it was in compliance with the 15-foot setback, you would have very little room between that and the parking area
That's correct.
to the front of the house.
That's
Is that
correct.
correct? At the present time, it looks like that's lawn.
That's correct.
Is that intended to remain as lawn? Is that the
Yes,
landscaping that?
They would probably extend this landscape area that's existing in the front of the house over to in front of the proposed addition, and then keep a portion of lawn, something like this. Again, this is sort of supposed to represent what it would look like if that addition were to be constructed.
All right.
Yeah.
If you would like to speak, please approach, and we have to swear you in. Please state your full name and your local address.
Sure. Well, thank you for to the board. My name is Frank Graybiel, and I'm a owner, along with my wife Lauren, of 613 5th Street in Bethany Beach.
Do you swear or affirm to speak the truth in this proceeding?
Yes, I do.
All right, proceed.
I just wanted to make a couple points along with what Ray has said, which is the importance of keeping the integrity of the site incongruent with what the existing house is. It's, you know, the inside of the home is a log cabin structure, so it's unique in preservation of the cottage feel and environment that it's kind of lost a little bit in Bethany Beach. We thought really hard and long about preserving not just what was done with the existing structure, but also what is contemplated for the expansion. You know, our primary reason to do this is not only from an integrity perspective and aesthetic and all the other things that Ray had mentioned, but you know, the fact that we have two small bedrooms in a space where we have a much larger lot to support a much, you know, bigger property. And I think the other thing that I wanted to point out was that, you know, we do have a little bit of a legacy of if you want to call it legacy or history, of being consistent and preserving the integrity of the cottage feel is, you know, we bought this back in 2017. It was built in 1963. And when we were looking to do some renovations and figuring out what to do in preserving what is there today, is that you had a number, actually not just a number, but almost every single contractor that said, hey, you know what you should do is just tear down the house and build something bigger on the 2 lots, or let's just keep the one house and move it on one of the other 2 lots and build you another home. And you know, we were reluctant and really didn't want to do that just because of the genuine feel and history of the place and what it, I think, represents to you know, to us. And you know, we're community people, so we just, you know, wanted to keep the integrity of that. But my main point of getting up here is not just to mention those things and a little bit of history, but the fact that, you know, this is all requested from the perspective of you know, utilizing and having space that will allow us at least, you know, an extra room and for bedroom and an office and things like that. We've thought really, really hard. Your questions about, you know, on the west side, do we bring the cottage up? That way you don't have to go through all of this, right? At the same time, you know, we're really thoughtful about the aesthetic appeal, curb appeal, and so forth of what it would do, and just didn't think, honestly, it was much of an ask in the long run, and had even gone so far to talk to neighbors about it and what their thoughts were, and not that we had to do that of any kind, but you know, we're very fortunate and privileged that they were very supportive of it. So there's considerable rhyme and reason for all of this, and just isn't something to try to maximize, you know, a land grab or density that, you know, we obviously have the opportunity to do either on the, you know, the south side of the house or toward the water. So I just wanted to make those points and just thank you again for the consideration.
Thank you. The location of the hallway,
Yes.
the picture window, the middle picture there on the top indicates that towards the front of the house there is a picture window.
This is the window that we're
Right.
talking about, but yes, there are windows here on that front porch, enclosed front porch.
Oh, okay. And so you're trying to position that hallway so that you can preserve that existing window?
That's correct.
In the second that's all the questions I have for you.
Thank you.
Thank you. In the expansion, considering the inmate definiteness, is that a word? The unsure use of this building, and it's extending 6.5 feet into the rear yard. Was there any consideration to just putting the rear of the expansion at the setback line?
Yes, as I stated, the Graybeals hope to put a third bedroom into that expansion, as well as an office for Mr. Graybeal and a small utility room for their washer dryer. And we felt that we would need that much space in order to accomplish those goals.
And the picture window will be looking at the expansion.
That's correct.
Okay. Thank you.
Thank you.
Yeah, I follow up on that. You've got a big picture window, and apparently the hallway in between them was partially put there in order to protect the view out of that window. Well, you'll be looking at the side of the addition if in fact it's done that way. So what is the logic of just having a little 4-foot by 8-foot walkway into the addition, and why not connect it with the rest of the house?
The main reason was to minimize disturbance to the existing structure, so as not to take out an entire exterior wall. The view from that picture window, yes, would look at the existing structure. It's possible there would be a window on this side of the proposed addition as well as some landscaping in the area between the two structures. But the main reason for proposing just that hallway as we're showing it was to minimize structure to the existing cottage house, which, as Mr. Graybill said, is rather old.
Okay, and a further question. Knowing that you would be out of kilter with the ordinance by putting the back of the addition into that 15-foot space, this was totally intentional, and part of it was to be able to maintain the plantings, et cetera, in front of the addition to the house. I don't know why you would want to have a variance if you could avoid having a variance with the lot this size and it still maintain the character of the cottage that's there.
The owners just felt that that was the best way to, again, balance the architectural, again, keep the balance between the existing and the proposed structure.
And if I could,
Please approach.
what we also tried to keep in mind is encroaching.
Excuse me, could you speak into the microphone because?
I
thank you.
apologize. So we are also cognizant of is encroaching on the west side of the boundary as well. So instead of trying to go toward the variance that would allow a little bit closer to the neighbors on the west, it just felt less intrusive, quite honestly, to come back. It's not ideal to come back as long as it shows, because we'd rather go as, if the opportunity would present itself farther west, but we didn't, we tried to keep that in mind as well. So that's the, and ask for consideration to go west as well. And
But that boundary is within the requirements of the ordinances as far as what, 7 feet? It's more than 7, well, it tapers down to 7.2 feet, according to your plan here. So that is within the code.
yes. Yeah, and then again, to reiterate, coming a little bit closer to the south, moving it up this way, the consideration is, is certainly curb appeal, aesthetic, and at the end of the day, it'll be function.
Thank you.
Steve?
Yeah, thank you. Considering the extraordinary and exceptional conditions, you mentioned that the site condition is limiting what can be done, and then there was a mention of keeping the plane of the home. You're defining the plane of the home as behind the porch.
Correct. The sort of the main central structure of the home is here.
Right.
This is just basically an enclosed screen porch, or enclosed porch
Yeah,
at the front of the property.
yeah. You could keep the plane along the porch if you moved it up, sorry, excuse me, versus keeping it back.
Yes.
And I was just wondering what, thought process went into keeping it back versus pulling it up to the plane of the porch.
It was discussed, and again, the owners felt that keeping, the addition, the structure of the addition is fairly substantial, and they felt it would be better balanced with the rest of the home by pushing it back that far. It's their aesthetic concern.
And then for the peculiarity of the lot, I think the canal would be considered a natural condition, correct? But I was curious to know what other peculiarities you think might exist. I think landscaping is something you've
Well,
thought of.
again, as we talked about, as far as the addition goes, again, this is more of the public portion of the house, with the kitchen and seating area, the deck and everything. So it made more sense to have the addition on this side rather than on this side. So that's part of why we're doing that. And as far as the pool and the deck expansion, again, they wanted to go back rather than to the east, again, because they didn't want to build any closer to the canal to try to protect it as much as possible. And as well as the existing landscaping that they've constructed there.
Yeah, and for the pool, that deck is raised. Is the idea to have the pool in line with where the pool? Have the pool in line with where the deck is?
Yes, the pool would be a
Ra-
deck.
It would be raised.
Basically, yeah, so the deck would expand out this way, and the pool, yes, would be at that.
Would be raised, yeah.
Yes, and then there would be, obviously screening and everything underneath.
Mhm.
Or foundation for the pool, however it's going to be constructed.
Yeah, it wouldn't sit above, on top of the deck,
Or below.
it would just be flat.
Would be flat with it.
Yes, even with the deck.
Okay, thank you.
And related, I know we're talking about different ordinances of 500 with respect to the pool setbacks and things like that. We would comply with whatever needed to be done. It wasn't, the intent wasn't to, push the envelope of the pool itself to be, not in compliance with any kind of, distance from where the deck ended to where the pool began, that kind of thing. So just wanted to make sure that that was articulated here, that, the idea isn't to build the biggest pool we could, and, compromise code and things like that.
Thank you.
Anything else?
Yeah, I'll ask another. On the pool, we're talking about it being even with that deck. Tell me again on not having it to the right of the home. I guess that's the east side of the
Yeah.
home facing the canal. And I understand that canal floods, but just wanted to understand again that
Right.
thought process of having it behind the house versus to the side of the house.
I think that really is the major consideration, is that to go this way, we're going closer to the canal, closer to an area that has potential to flood, whereas if we're going straight back, it keeps the existing line of the deck, and it's just a minimal expansion rather than, more involved redoing of the deck. That's also part of
And honestly, we didn't want the deck to be the primary, driver of aesthetic or function, to bring it out closer to the water.
Yes.
And have, quite honestly, a pool be the focus of what is a very cottage, small, intimate environment.
Great, thank you.
I believe we have an individual here who had indicated she wanted to speak in support of the application. Unless you have anything else you would like to add at this time.
Just a small, short closing summary. The Gray Beals are clearly invested both figuratively and literally in preserving the beach character of their home, their property, and their neighborhood. It would have been much simpler, as Mr. Graybeal said, to simply demolish the existing home when they bought the property and rebuild a larger structure, potentially out to the setback lines. That would have ignored the character and the history of the place. Instead, as the residents of this community, they chose to preserve it and enhance what was there. They saw the value in it. They're asking for your consideration to make their permanent home more livable and to better suit their lifestyle. Thank you.
Thank you. Please approach the podium. Please state your name and local address.
Janie Switzer, 318 Wellington Parkway.
Could you speak a little louder, please?
318 Wellington Parkway, Janie Switzer.
Thank you very much. Do you swear or affirm to tell the truth in this proceeding?
I do.
Please proceed.
Thank you for the opportunity to speak. I attend a lot of these meetings, and I am not only a homeowner, but I'm also a builder. And this is one of the seriously most sincere requests that I have seen in the last 2 years. The Graybeals live in a cabin, as they have stated. It has integrity, and what they want to do has integrity. And I have a high respect for the code, but I think in this case, these variances should be considered. They have a house that's on property that's more than 2 lots, as has been stated. They could do exactly what Evergreen Homes did across the street and take down 50 trees. I don't know how many trees it was maybe probably more than 50, and strip the land and put up 3 houses to the bulging perimeter of the lots. This is not what they are trying to do. They are trying to keep the integrity and character of the area and for their neighbors. And I don't think that this would have any adverse effect on their neighborhood by any means, or on their neighbors. And you've already gotten positive feedback, written feedback from at least 4 neighbors, and I support that. I think their situation with the house on 2 lots is they're doing the best they can to maintain the architectural balance of the area and of Bethany Beach, which you don't see that often. I think their variance requests are reasonable, and sometimes these types of requests aren't reasonable based on the lot and the area that they're in, but I think in this case it is, and I think it's more important to move that addition back for the integrity of their cottage than it is to move it forward to comply when the back western part of their property is sheds from neighbors. So I think it's more important to leave the addition back than to move it forward, because I think it will take away from the integrity of what they're trying to accomplish with the cottage feel and to maintain some yard. So those are basically my comments.
Thank you very much. Any questions?
None. Thank you.
Thank you.
Thank you. At this point, we will close the hearing, and proceed to our deliberations on the matter. Applicants seek variances from Section 425, zoning, Section 425, Appendix 3, Table of Dimensional Requirements, minimum yard depth, rear. The application requests that the requirement for a minimum rear yard setback of 15 feet be reduced to 8.4 feet for an addition to be constructed on the left side of the existing dwelling, and to 6.3 feet for an elevated deck, pool, and pergola to be constructed to the right rear side of the existing dwelling. Under Section 425-105D of the Town Code, and considering an application for a variance from a dimensional requirement, the board is directed to consider whether, quote, owing to special conditions, a literal enforcement of the provisions involved would result in an unnecessary hardship or exceptional practical difficulties. Approval of the variance requires that the board find four specific standards are met. The first of those is extraordinary and exceptional conditions pertaining to the particular lot or structure in question because of its size, shape, or topography. The applicants argue that the lot is unusual in that it affords room for both the existing house in the center of the property and surrounding landscape. They wish to preserve the existing landscape as much as possible while still expanding the dwelling and deck with pool. The topography of a lot, though not defined in Code Section 425-20, normally encompasses the arrangement of the natural and artificial physical features of the area. Accordingly, it is permissible to consider the landscaping as a pertinent condition of the lot. As you can see, we've all been trying to grapple with this idea of why, since it's possible to position the addition on the left in a manner that would comply with the rear lot setback, does that, are there extraordinary and exceptional conditions pertaining to this property that would justify the waiver you're requesting? I personally am sympathetic to the idea of trying to maintain some open space between the addition and your parking lot. I think you would have better curb appeal, you would have better aesthetics with the lot. But I can see that, you know, that's a fairly close call. I personally am sympathetic to it. The second item is application of the code to this particular lot or structure and whether that would create an injustice. Again, the way the wording of this portion of the application, it says, the existing home is relatively small, contains only 2 bedrooms. The owners wish to expand their home to add a third bedroom and office space to make the house more functional. Rather than demolish the existing cottage-style house, they want to preserve the existing beach character of their home and landscape by expanding the house and deck. Now, that sort of presents the alternative to complying with the setbacks as demolishing the house. I don't see why that would be the necessary alternative to compliance. But I do, again, because of the sympathy I have about trying to maintain a better aesthetic at the front of the property, I can see how you, as the owners, would view it an injustice not to permit you to locate the addition where you desire. The applicants on the third condition, peculiar to the particular piece of property involved. I think that, that the overall conditions of this property are peculiar, given the size of the lot, given the existence of the current property, and so on. Whether a variance, if granted, would cause substantial detriment to the public good or impair the purpose or intent of the code. In my view, it would not cause a substantial detriment to the public good. All of the contiguous neighbors have expressed their support for the application, as has, I'm sorry, I've forgotten your name, but as has Ms. Switzer in her comments here in support of the application. The quick check standards, I believe, are met. It's a residential area. It does not appear that the variances would seriously affect neighboring properties. Applying the balancing test between the negative effects to neighboring properties from granting the variances versus the hardship or difficulty to the applicants if the variances are denied, I would come down on the side of granting the variances to make what I view as normal improvements in the character of the residential use of the property. Sherwood.
Thank you, Mike. My concern about the expanding into the rear of a setback, the way I see it, it's a choice. There are alternatives available. However, looking at the 4 requirements, the last one, the variance would not cause a detriment to the community. Certainly, Susan had told us that, as well as with the neighbors' letters. So I am in favor of granting the variance.
Jack?
Well, in looking at the requirements and the idea behind us, as Sherman said earlier today, is the idea of not granting variances just because it's the nice thing to do, in my feeling. When I look at this and look at our requirements, there are no exceptional conditions regarding this lot. It's two lots, they're next to each other. They are sort of standard lots over in the canal area of town. So we wouldn't meet that requirement. It would not create an unnecessary hardship if in fact we were to do this. There are other solutions to what the people who are requesting the variance could do. The conditions such as are particular, they're not particular to this property in itself. They're, as pointed out, all along the canal, big houses are going up, and while we like it or don't like it, this is not an unusual thing to happen. And the variance, if granted, would not cause substantial detriment to the neighborhood or the people there. So in looking at it, I see it's nice to want to do it this way, but if there are alternatives within the ordinances as we have them, I'm not certain that we ought to allow changes to those ordinances, in that they are for the greater good of the whole community and not necessarily centered within this particular area. So while it goes along with, they do look like the neighborhood, there are supporting documents from the neighbors that are in favor of it. I believe that there are solutions to this problem that can work within the requirements of the ordinances that don't cause this committee or this board to necessarily grant any of these changes if in fact they can be made and worked with. And as mentioned earlier, I don't think it's very attractive to see a 4x8 hallway going into an additional building on the property, et cetera. It's, I think you can move things, you can do things, you have enough property to handle it, and so therefore I am opposed to granting this on the basis that you can solve the problem in ways that work within the ordinance. That's all I have.
Steve?
Thank you. In reviewing the application and what we heard, I struggled a bit, with the conditions of the property and the particular lot, but when we discussed the plane location of the addition, the driveway, I understand that uniquely this home that's there currently sits where it's located. There's a sufficient explanation for me to understand why there are site conditions that limit what is being proposed, where the location of the structures are going to be. For the location of the structures, I also took into consideration what was said about the flow of the home, the location of the structure, and wanting to keep the flow. In terms of the size of the lot and the existence of the current property, you're trying, as I understand, not to have major impact with construction. And I think the thing that brings me to favor of granting the variance, now I know that what brings me to favor is I'm sympathetic to the desire to protect the cottage fill and the preserving and enhancing the existing home. And what was really helpful for me in terms of the public good was seeing the letters of support from neighbors, but most particularly Paul Michelle Simon, which is right next to where it seems the wall, but the addition will go, but they're in support of it. So that was helpful for me, on the basis of that almost alone, that I think this is, I'm in favor of granting the variance. Thank you.
Okay, may I have a motion?
I make a motion that we accept the variance application.
Okay, a second?
Third?
No?
No?
You second that?
I second
Steve?
that. I'm sorry.
Okay. All in favor? Raise your hand, and say aye. Aye. All opposed? So the board has voted to approve the variance application. A written decision will be forthcoming, setting forth the details, and with that, this hearing is concluded. Thank you very much.